All right, technical difficulties resolved. Mr. Lewis, you just finished with your explanation of the change regarding another election. And so, Commissioner Baker, did you have any questions for Mr. Lewis before we open this up to public comment?
No, I think I'd like to hear the public comment a little bit first, actually. The issue that you addressed with respect to the definition of different election and another election was anticipating my first question. I'm very interested in hearing the comments.
All right. Without further ado, let's go ahead and open it up to public comment from interested persons. This is item 3. Do we have any public comment? Does anybody wish to make public comment on item 3? This is the interested persons meeting. Hearing and seeing none. Commissioner Baker, did you have any further comments?
I do for now. Thank you very much. And it's mostly just to make sure I'm super clear on the requirement to get prior permission before putting excess contribution into a different election, meaning other than the primary or general for the same election. So I'm looking at subsection A on attribution. So can you point to the statute on or explain where we are getting the authority to require a prior notification when it's not, when the excess funds are not going to the primary or general for the same election? I just want to ground that in our regulations.
Yeah, so to repeat the question and make sure I understand correctly, you were asking what is the statutory authority for our proposed requirement in G, proposed G of the regulation, that a committee must secure notification before attributing contributions to a different election? Or are you asking about me to clarify the requirement in D1 of the statute?
Well, both actually would be helpful.
Okay, sure. So D1 of the statute, as you know, says that a committee may, but then says in accordance with any regulations adopted by the commission, request that the contributor attribute in writing a contribution to a different election. And so we have then drafted the requirements for so informing the contributor in accordance with that instruction from the legislature.
Okay, so we're, again, the statute's not saying that prior notification, written notification has to happen for purposes here. It's the general in accordance with regulations submitted by us.
Yes, so in subdivision A
Of the statute of the regulation.
Sorry, of the statute, it says of the regulation, it's actually a reference to a subdivision A of the statute, which is in subdivision A of our regulation. So we say in A of the regulation, a committee that elects to attribute a contribution or a portion thereof that exceeds the applicable contribution limit set forth, lists the statutes, to another election pursuant to A or B must obtain written confirmation from the contributor. Again, that's extrapolating from interpreting and implementing from the statute, which says that a committee may return or attribute another contribution in accordance with subdivision D, and then D refers to requesting that the contributor attribute it in request in writing rather from the contributor that they may attribute it to another election. And so we then are implementing essentially that cross-reference in statute.
So
Okay.
just so I'm
I-
clear, hold on, Commissioner Baker. So Mr. Lewis, is what you're saying the regulation, the requirement, the regulation for prior notification is coming directly from the statute?
Correct.
Okay. I just want to make sure I'm clear.
Yes, and the language in the statute is in accordance with regulations promulgated by us
Correct.
in sub D1. Request that the contributor attribute. Thank you. I just wanted to kind of get that on the record for posterity, that is something that is grounded in the statute itself to be able to do that notification requirement. And you already answered my questions about how we've changed the language from pre-notice regarding another election, different election, very next coming up election. I think that was it. I just wanted to ground that particular point for starters. Thank you.
All right. Thanks, Commissioner Baker. I'm going to call again. Is there any public comment or interested persons feedback on item 3? This is our discussion of the regulation implementing the return of excessive contributions law that was enacted last year. All right. Hearing and seeing none. Mr. Lewis, do you have any final comments before we proceed with our next item?
I do not. Thank you.
All right. Thank you. We'll see you in May.
That's right.
All right. Thank you. All right. Let's go ahead and move to item 4 then. This is our legislative update. And we will welcome to the table our senior FPPC Legislative Counsel, Ms. Nakano.
Good morning, Chair Matich and Commissioner Baker.
Good morning.
All right, I've got updates today on several bills, including both commission-initiated bills and other PRA-related bills. There are also a number of new bills that I will go over today. I'll start with the FPPC-initiated priority bills. I'll go in order, the order that's in the legislative report attached to the agenda. AB 868 relating to the Data Act, the bill that would create a public record of state-level online campaign ads, was heard in the Assembly Elections Committee on March 29th. It passed 6-2 with the Republican members voting no. It will be heard next in the Assembly Appropriations Committee. The bill was also amended on March 30th, consistent with committee recommendations. The amendments make 3 changes. First, they provide that the requirement to submit ads begin on the January 1st, that is at least 60 days after the Commission has certified a system for accepting these ads. Previously, this would have commenced just 60 days after the Commission certified the system. Second, the amendments make a correction to the enforcement provisions in the bill to clarify that the $10 per day late fee is the exclusive remedy for any late reporting that is unintentional. Previously, this said negligent. And last, the amendments add Assemblymember Lee as co-author. Next is AB 1170, the bill relating to electronic filing of statements of economic interests. That bill was amended. At the time of last month's commission meeting, the bill was a spot bill, but it was amended and now includes the substantive provisions. Specifically, the bill requires certain officials for whom the commission is the filing officer to file electronically using the commission's electronic filing system. And the bill also allows filing officers to retain reports and statements immediately in electronic form instead of having to retain them in paper form first for at least 2 years. The bill is very similar to AB 975 by Assemblymember Rivas from last year, but does not include the provisions relating to the gift rules and does not include the provision that the Commission expressed concern with at the end of last session that would prohibit the Commission from posting online the SEIs of individuals other than certain elected officials. This year's bill also aims to address security and privacy concerns by requiring redaction of additional categories of sensitive information on statements that are made publicly available by the Commission online. This would include redaction of the personal address and telephone number of the filer, and the street name and building number of the filer's business address and any real property interests. Regarding the filer's personal address, I'll note that it's unusual that a filer's home address would be listed on an SEI. It's generally not required, but there are a few scenarios where it can occur, so this redaction requirement would help in those cases. Next is SB 29, relating to the Commission's Political Reform Education Program. Just a short status update on this one. The bill passed in the Senate Elections Committee 720 and will be heard next in Appropriations. SB 678, this is the bill that would require disclaimers on online posts in cases where a committee pays a third party to post content supporting or opposing a candidate or ballot measure. That bill is set for its first hearing on April 18th with the Senate Elections Committee. And last, for Commission-initiated bills is SB 888, authored by the Senate Elections Committee. And I'm happy to announce it's the vehicle for two of the Commission's legislative proposals, including several minor and cleanup changes to the Act, as well as the proposal that would increase privacy and security by requiring redaction of bank account numbers and street names and building numbers from campaign filings. That bill will also be heard in the Senate Elections Committee on April 18th. And I'll pause here for any questions on Commission-initiated bills.
All right. Thank you, Ms. Nakano. Commissioner Baker, any questions for Ms. Nakano on the Commission bills?
Yes, please. The second one, that was Assembly Member, I believe, Valencia.
Yes.
You mentioned some of the information that would be redacted. And it looks like from your summary that it's not only your home address, although typically they'd use the agency they're with as an address, but any real property interests. So I'm just wondering about that. If somebody has investment property, whatever other real property interest they have, if those addresses are redacted, I want to make sure there's transparency for conflicts of interest, and knowing that's maybe something that somebody would be voting on is within a certain geography to that real property and interest. So I'm checking on that.
Yeah, that's a very good question. The bill would require only the street name and the building number to be redacted, so the public, at least on these online filings, would still have access to the city zip code to have an idea of where this property is located, and if there was a concern, they could request a paper filing of the statement to get the full address.
Thank you. Just expressing my preference, and I can put some more thought into it, but it sounds like the public would have to go through an extra step they don't currently have to go through now to determine if there are concerns about conflict of interest. They'd have to request one. And I'd be curious, and I welcome the chair's thoughts on this, on how wedded the author is to redacting the addresses. It seems to make work for the public and the transparency provisions to try to find potential conflicts of interest by redacting addresses of other real property interests that are not, say, a primary residence, which certainly makes sense. I'd like to know how wedded the author is. And Mr. Chair, you may have some good insights on this as well, but I'm hesitant to be raising an extra step for people to do.
Yeah,
what do you think?
It's an issue that we've talked about previously with respect to this bill. And as I recall, we solicited the input from the Enforcement Division and other folks on that specific question. Would this possibly be detrimental to identifying conflicts of interest? And the consensus view, at least internally, was that it would not be. That the additional one, you can still get the full address by simply making a request for the paper copy. That's pretty common, and it's usually provided very quickly. So staff's perspective was that this wouldn't be a detriment to enforcing the conflicts provisions in the Act. I think to the extent that we want to suggest to the author that perhaps, is this necessary? How strongly do they feel? I'm certainly fine having Ms. Nakano have that conversation, report back to the commission on it, and get some further gloss for the commission on it. But again, having had the conversation with staff, their view was that this would not be a detriment to the conflicts whatsoever.
Thank you. That would be my request, that we just check in with the author and find out how strongly, again, wedded they are to it, or if they are flexible. We'll see, take their temperature on it. I appreciate that our team would be very quick in responding, I'm sure, to a request, but it's just another step for the public to take. So hopefully that's my feedback, and we'll see what the author has to say.
Right. Anything further on the other commission bills before Ms. Nakano continues? Commissioner Baker?
No, thank you. Thank you for the report so far.
All right. Ms. Nakano, please continue.
Thank you. All right, we'll move on to other commission-related bills. Lots of updates here. The first is AB 37. This is the bill that would make changes to expand permitted use of campaign funds for security expenses. That bill passed in the Assembly Elections Committee 720. There were questions about this bill that came up during the last commission meeting, including what the problem is that the bill is aiming to solve. I've been in contact with the author's office, and they responded that the requirement in existing law to verify a threat before being allowed to spend campaign funds on security expenses is something that is not required in other areas. That is, there's no requirement to show proof of need for other campaign expenses. So I think the implication here is that it's not either necessary or consistent with how other expenditures are treated under the Act. I also asked about whether they would consider a monetary threshold, and they responded that generally different officials will have different needs. For example, if an official is receiving threats and they have a large family, they may need to spend more money on personal security than other officials. And I think the implication here is that it would be difficult to choose an appropriate limit because of those different needs. I also asked whether they have seen a demonstrated need to expand the law to allow security for staff, candidates, and elected officials. And they responded that they don't have statistics, but staff are included in the bill as a precaution. And if threats are significant enough to warrant extra security for staff, they want to have that flexibility to purchase security equipment or other kinds of security. They also pointed out that on social media, it's not uncommon for staff to be tagged in posts by the campaign or the elected officer, which creates some opportunity for staff to be targeted. There was also a question about reimbursement and whether for security systems in particular, if these systems could be treated like other tangible campaign equipment. We're still looking into what the options are here. One option might be to require that if the person retains the security system equipment in their home, they'd have to reimburse the committee for the fair market value of the equipment in its current state. But we don't have any agreement with the author's office yet. They are open to feedback, though.
On that last point, that is existing law, isn't it? That there would have to be reimbursement after the fact.
Existing law requires that when the property is sold, reimbursement must be made to the committee.
Okay.
All right.
Before you go on, also on that last point about existing law, so when the property is sold, reimbursement has to go to the committee. What if the committee is closed? Or the official's no longer in office, and perhaps the security need, I guess the second question would be security need, but on existing law, what if the committee is closed?
That's a good question. The text of the statute does not provide for that situation. I'm not sure how we've treated that in advice or otherwise, but that's something we can look into and I can report back on.
Thank you. I think we probably have had some items of value that when a committee is closed and the person's, say the candidate or the official is going to receive the benefit of that going forward, there's some kind of reimbursement. I'm sure we've got some, and I'd be interested in seeing that. And the advice letter itself, or whatever the basis is. And I started diving into a second question on that is if the official, are they open to or contemplating the possibility of when the official is no longer in office, or again, when the staff is no longer in office, if not just reimbursement, I suppose, the committee, just what would happen with that material, both for staff and the member themselves. Because again, we talked about how staff could be in an office for 3 months, whether they've been tagged on social media or not, get the security and then be gone, and want to know about that.
Okay, thank you. I'll look into
Thank
that
you.
as well.
Go ahead and continue, please.
Okay, the next bill I have an update on is AB 270 by Assemblymember Lee, with Senator Umberg as the principal co-author. This was previously a spot bill, but would now amend the PRA to allow public financing of campaigns under certain conditions, including that a state or local governmental entity creates a dedicated fund for this purpose. The language is actually very similar to existing law passed in 2016 that was declared void and unenforceable as an improper legislative amendment of a voter initiative. However, AB 270 attempts to address this deficiency in the previous law by requiring that the bill go to the voters for approval if passed by the legislature. Also, unlike the 2016 bill, AB 270 would prohibit the money in a state or local government's dedicated fund from being taken from money that is earmarked for education, transportation, or public safety. The next bill is SB 24. It's actually identical to AB 270. This one has Senator Umberg as the author and Assemblymember Lee as the principal co-author. I anticipate that at some point one of these bills will pull forward as the vehicle that they continue with.
Can I ask a question about those two bills? If either of those bills were passed and then approved by the voters, do we have any idea what the fiscal impact would be for our agency at this point? I know it's early, but I'm just curious.
I don't believe that we've collected that staff input yet. We don't have a fiscal yet. Okay, moving on, SB 328. This is the bill that would expand the Act's contribution limits to all local elective offices, including school districts, community college districts, and special districts. This bill passed in the Senate Elections Committee 6-0 with Senator Wen not voting. Next is a new bill, SB 573 by Senator Wahab. The bill would prohibit employees designated in the Senate or Assembly's Conflict of Interest Code from registering as a lobbyist, working for a lobbying firm, or working for a lobbyist employer for 2 years after leaving employment with the legislature. The bill would provide that this restriction does not apply if the individual engages in lobbying activity on behalf of a 501c3 nonprofit. SB 681, the bill that would shorten the number of days that a PRA bill must be in print before being voted on, passed in the Senate Elections Committee 6-1 with Senator Wen voting no. That bill was amended also to require that PRA bills must be in their final form for 7 days before voting by either house, except that the existing 12-day requirement would apply if the bill did not previously amend the PRA. In the introduced version of the bill would have required only a 5-day period in print. SB 724 by Senator Glazer relating to reporting payments for communications that identify an elected state officer, passed in the Senate Elections Committee 6-0 with Senator Wen not voting. And another new bill, SB 858 by Senator Nilo, would transfer the duty to prepare the official summary of measures that will appear on the ballot from the Attorney General to the legislative analyst. The bill would also transfer similar duties that appear in the Elections Code, and the whole bill is contingent on the passage of another bill that makes similar amendments in the California Constitution. And this bill is on our radar because it's within the PRA, but technically does not affect us in terms of our duties. Last, the next hearings for the Senate and Assembly Elections Committees will be April 18th and 19th, respectively. I've mentioned some of the bills that will be on those hearings calendars already, but I'll go over all of those just so they're on your radar. The Senate Elections Committee will hear all 3 of Senator Newman's bills. That's SB 248, 251, and 409. SB 858 by Senator Nilo, and the commission-initiated bills, SB 678 by Senator Umberg, and SB 888, the committee bill. The Assembly Elections Committee will hear AB 270 by Assemblymember Lee, AB 334 by Assemblymember Rubio, and AB 1170 by Assemblymember Valencia. That concludes my update, but happy to take any questions.
Thank you, Ms. Nakano. Commissioner Baker, any additional questions or comments for Ms. Nakano?
I think it's a comment in response to the chair's question about how much the public financing bill may affect our agency in terms of budget or otherwise. Did you say that the bill is very, very similar to the 2016 law that was later found unenforceable or unconstitutional? It would be dated. I'm sure there was a score, or they call it that, or the finance department may have done something along those lines. If it's sufficiently similar, if this continues to proceed, obviously I think we'll get some numbers on it, but that may be something that could be responsive to the chair's question, although it would be, of course, dated information.
Thank you.
That's a good point. All right. Any other questions or comments for Ms. Nakano? All right. Thank you, Ms. Nakano.
Thank you.
All right. That brings us to our final item. Item 5, discussion of items for the May Law and Policy Committee meeting. I confirmed with Mr. Bainbridge before the meeting started that we will, the plan is to have our next batch of updated regulations for Senate Bill 1439, these are the Levine Act regulations. And I understand, Mr. Bainbridge, that you're having an interested persons meeting in April following the commission meeting, the day after the commission meeting as well on those regs. Is that right?
That's correct. On the 21st of April, we're having the interested persons meeting.
All right. We look forward to that, certainly. Commissioner Baker, anything else other than the normal legislative update and the regs for the May L&P meeting?
No, those are pretty, excuse me, those are pretty substantive topics for that meeting. So I think it's good to stay focused on that. Thank you.
Very good. All right, that brings us to the end of our agenda. I will go ahead and make a motion to adjourn. Do I have a second, Commissioner Baker?
You do. Second.
All right, Ms. Lineker, please call the roll.
Commissioner Baker,
Aye.
Chair Match.
Aye.
The motion passes.
All right, thank you, everyone. We will see you later in the month for our commission meeting.
That's right. Have a good day. Thank you.
Take care.